We're going to start with Nadim Bardawil. Nadim is a senior associate in his firm's corporate M&A and intellectual property practices, based in DIFC office in Dubai. He specializes in transactional corporate work, mainly in the oil and gas, hospitality, and media industries. Nadim advises on a range of local and international corporate and commercial matters, including joint ventures, commercial agency, private equity, employment, and regulatory. He has assisted clients in implementing mergers and acquisitions, as well as presented clients in the negotiation of IP transfer and licensing provisions. Nadim is fluent in a number of key languages, including English, French, and Arabic. Nadim holds a JD degree from the Hofstra University, am I saying correct? Good. School of Law, and is admitted to practice in the state of New York. He also holds a business management degree. So, please, Nadim, the floor is yours.
Thank you, Ahmad, for the introduction. Good morning, everyone. Happy to be here and be able to speak to you about this exciting topic. When it comes to intellectual property, at least for private practice lawyers, M&A deals is probably the most exciting part because it's the most revenue making. But it's also exciting because there's a lot of issues to be able to tackle. And so what I'm going to do is I'm going to take you through a short overview of a couple of points that are important to keep in mind when handling IP or discussing IP in an M&A transaction. I'm going to briefly touch upon due diligence and a number of other key aspects, as well as share some personal experiences that may be helpful. So the due diligence process in any merger and acquisition deal is probably the most important and the first part of such a transaction. When you have, in M&A deals, usually you have complex transactions, and over the last decade or so, you have seen, or we have seen, the assets that are being purchased in deals being more focused on IP as opposed to brick and mortar assets. And this means basically that companies have become more savvy to look out for intellectual property, and mergers and acquisitions in general have focused more on IP as opposed to brick and mortar assets as the substance for the purchase, for the acquisition, the merger of two businesses, whatever it may be. A lot of times we were just speaking about this with some of my colleagues here on the panel, that IP is looked at as a last point, or even not even on a due diligence checklist. It's important because the IP portion of due diligence can take a lot of time for it to be front-loaded. That is to say, it should begin at the start of a DD procedure. And it's important also to look at valuation when you're looking at these IP rights. Why is the acquisition taking place? Is it taking place because these IP rights are key to the business? Is it taking place because the business is trying to enter into a new field? Although these may not be legal questions, as a GC or as an in-house or as a private practice attorney, it's important for these questions to be discussed and asked. It's also important to take finance and business risks into consideration, and to decide whether, for example, it may be more cost effective to create this IP from scratch, or if purchasing it may be helpful from a litigation perspective to either dissuade or block other entities from being able to use it, or to gain any key advantage in any technology, in a technological landscape going forward. One thing to keep in mind that's very important when we look at IP in a merger or an acquisition is who holds the rights. Given my practice being in the UAE and the Middle East, I can share a bit of insight from the Middle Eastern region. In the UAE, you have the Ministry of Economy which handles all of the registration of all IP rights. And the way that it works is that they will issue you a certificate for any IP right that is registered. Now, while there is a search function with the Ministry of Economy, you can go and make a search on a specific IP right. Sometimes it may be difficult to pinpoint exactly who owns the right or what the right might look like, if it's a trademark, a logo, or a patent. These things are a bit more difficult to ascertain in this market as opposed to other more mature markets from an IP perspective. When we look at trademarks, it's important to look at what classes the trademarks are registered in, what are the goods and services, and not just that a trademark is registered, because it may affect the business in the long term. And from a patent perspective, always important to look at whether there are any joint owners of the patents or whether there are any assignments to the inventions. Another key point to look at is whether these IP rights have been licensed. So many times when you go through a merger and acquisition and you review key contracts, you may not see license agreements in relation to IP. You may have had a license agreement done 4, 5, 6 years ago, the term has expired, you've had automatic renewal of the term, but no one's paid attention to it. And all of a sudden you're purchasing an entity which owns key intellectual property without knowing that part of it has been licensed. So it's very important to look at this, very important to ask these questions. These rights may also be subject to exclusive or non-exclusive arrangements. Particularly in this region, we see a lot of IP coming from outside the Middle East, coming in to be licensed to be used in the Middle East. And so it's important from a Middle Eastern perspective, we always look out for this. We always try and ask these questions to make sure that clients are aware that when you have IP, you need to think about licensing. You need to think about whether this IP is being used by someone else, where it's being used, who has the right to use it. And again, a lot of times these arrangements may not be registered. So unless you have disclosure from the target, you may not know exactly what's going on and what the background is. Of course, litigation, I'm sure this will be discussed by my colleagues as well, is very important. Litigation risks are important, but we also need to look at whether you may need to spend money to enforce these rights that you're purchasing. So whether they may be already infringing marks out there, whether this IP is subject possibly to any counterfeit products being sold in the region. It's not just about whether the rights are owned properly and registered properly, but whether there's going to be a cost in the future to defend ownership of these rights. Again, when you look at, when you go through a merger and acquisition process, many times you're going to have just a bunch of documents that are going to be provided. Very rarely will you see cease and desist letters or legal opinions obtained by the target company as part of this due diligence packet. And these are very important because you may have cease and desist letters sent from companies or entities which believe they own the right to this IP or believe that this IP that you're purchasing is infringing on their marks. And you may not know this unless you have access to these letters or unless you have access to any legal opinions that the target may have sought from their external counsel. So it's important to ask these questions, to keep these in mind. In terms of software, it also poses an interesting issue, which our colleague from Angeli is going to be speaking about, I'm sure, more specifically, because you have open source code to keep in mind. A lot of open source code and software is free to use, but it may be that software is based 90% on open source code and 10% on something that is proprietary. And unless you can distinguish whether that is the case in any IP that you're purchasing, you may be opening yourself up to potential litigation. That's also something to keep in mind. And lastly, I'm going to talk about barriers to use. Again, when you purchase IP, your intent is to use it. It's not for it to sit on a shelf unless you are trying to purchase it specifically to block other people from being able to use it, or if you're purchasing it to use it in the future. Most likely, you may be purchasing it to use it. And there may be barriers to entry that will stop you from being able to use it once you purchase it. It's a good example of this, and it's fitting given that the motor show is starting this week in Detroit, is a very well-known case that I'm sure you know about, which is Volkswagen purchasing Rolls-Royce a couple of years ago, or maybe 10 or 20 years ago. They purchased Rolls-Royce, and when the deal was done, they found out that they didn't own the rights to the actual trademark of Rolls-Royce. And so they had to do a second deal, and they had to purchase that separately, which increased their costs dramatically. So it's always important to look at, are there any barriers to use immediately? Are there any third-party rights that may be stopping you from being able to use this IP that you're purchasing? And also to account for unknown barriers. We live in a world where technology is becoming fast, very quickly is becoming the biggest substance in terms of IP, and it may be very possible to reverse engineer this IP that you're purchasing. If that is the case, are you overpaying for this IP? Should you maybe go back, as we said in the first or the second slide, and think about creating it yourself? Would that cost be lower? There also is the important consideration that the target may not have efficient privacy measures enforced. They may have been subject to a cyber theft attack over the last 2, 3, 4 years, and this IP may have already been stolen, may already be being used by someone else. Important to keep that in mind, and as well as the misappropriation of technology, where you have employees who may have created this and may have taken it once they left the company or shared it with competitors. These are may be unlikely, but it's important to keep them in mind. Again, important to ask these questions of the target when you're purchasing IP. Of course, all of these considerations can be solved with reps and warranties, but at the end of the day, when you're looking at a transaction, you want to be sure that you can lower any potential cost that may be coming up, and not just rely on representations and warranties in a sale and purchase agreement, especially given the fact that you have varying reps and warranties that can be enforced depending on the jurisdiction. A lot of times we see here in the Middle East that you have a sale and purchase agreement for an asset that is based on a UK or a US model. Well, these reps and warranties may not apply in this jurisdiction. They might not be able to be enforced. So it's important to ask these questions. Can this be enforced through the local courts? Do you have a trademark office that is savvy, sophisticated enough to recognize this? Will they have their own internal controls to recognize if IP is being copied or infringed upon? So all important questions to ask. I hope that this was insightful, and I hope that we can get more questions going once everyone's finished speaking. Thank you for your time.